Hello and welcome back to the Legal Cheek podcast. My name is Julia Szaniszlo and I'm joined once again by my lovely colleague, Ryan Scott.
Hi, everybody.
Hello, hello. Today is the first in a new series, which we'll be hopefully calling Practice Area Deep Dives. We'll be recording these episodes over the coming weeks and months, and these sessions will be designed to give you a high-level introduction to a number of different practice areas across the legal sector. They'll serve as a jumping off point for further research, of course, which you'll be doing when you're looking into law firms and looking into the different seats available in training contracts. But today we'll be starting off with dispute resolution. We're going to look at what it is, what the goals of dispute resolution are, what lawyers do when they work in this practice area, and perhaps even some key trends which are affecting the practice at the moment. So, of course, we need to start with what it actually is. Ryan, do you want to kick us off?
Yeah, so just for context, I was a paralegal for a while in dispute resolution. I did contentious insolvency work, which is a bit of a mouthful. We'll get to what that means a bit later. And then I worked in general commercial litigation for a while, doing all sorts of different subsets of dispute resolution. But dispute resolution is about assisting clients in civil disputes. So that can be distinguished from, I guess, a criminal case. In civil disputes, the clients will be seeking a specific end goal, like compensation for loss caused by a breach of contract, or compensation for money owed that hasn't been paid under a contract, or something called specific performance, where you're looking for the other party, you're looking to compel them to act in a particular way, so perform their side of the bargain, or an injunction, so you're preventing a party from acting in a particular way. So that might be like leaving a company early if there's a specific clause in a contract that says they can't do that. It's a very broad umbrella, as I say, and contentious work can crop up in all these sorts of different areas. So insolvency, employment disputes, real estate disputes, construction, banking, and finance. And most of the big firms you might be applying for will probably have contentious areas across the whole umbrella. But with that, we'll move on to the different forms of dispute resolution. There's mediation, arbitration, and litigation. I'll start with litigation and I'll hand over to Julia. Litigation is the typical thing you think of when you think of dispute resolution, the court-based dispute resolution procedure, what you see on telly that's glamorized. Um, with court-based dispute resolution, the decision of the judge is binding. There's comprehensive disclosure processes, so that's just where you've got to disclose documents that are relevant to the case. But the problems with it is that it's very expensive and lengthy. The proceedings are always in public, so I think of like the Christie trial, for example, like that didn't have a particularly great effect on the parties' reputations. It's also a very adversarial process that can destroy commercial relationships, taking them to court. But there's two more forms of dispute resolution: mediation and arbitration. Julia, do you want to cover what those are?
Yeah, of course. So, as Ryan said, litigation is a long, expensive process which can damage reputations. So, naturally, people who find themselves in disputes, companies, etc., they have been increasingly seeking alternative forms to this process. And the two that we'll cover today are both quite different. So, mediation, this is essentially a form of dispute resolution which doesn't have someone, a third party like a judge during litigation, or an adjudicator, as we'll see an arbitrator, as we'll see in arbitration. They don't have that appointed, and it's all about the two parties who are stuck in this dispute coming together, perhaps with an advisor, and trying to hash it out themselves. So obviously, the main pro of this is that if you're in some sort of a commercial relationship with the other party that you're in a dispute with, you have an opportunity to maintain that one, because this is much less of an adversarial process if done right. Parties also tend to have more control over the outcome. You're not going to have a judge telling you what should or should not happen. You can come to some fairly creative solutions. It also tends to be more affordable and quicker. You don't have the lengthy court process to reckon with. And that's an expensive process which requires all sorts of different parties, lawyers. Obviously, you can have a legal advisor during mediation as well, but it's much less extensive. Naturally, this means that both parties need to actually be willing to come to the table, and that can be a drawback. If it's gotten to the point of it being too adversarial to mediate, you're not going to be able to actually bring them there to actually discuss anything. And of course, decisions aren't actually legally binding. There's nothing, during that process, if you come to a decision, it's all about trust on both sides of the table. And you don't have a judge saying, this needs to be enforced. Arbitration, on the other hand, is another form of dispute resolution where you essentially appoint a third party, a neutral third party called an arbitrator, who will, often a panel as well, who will hear the case. And during the arbitration hearing, it kind of feels almost like a court hearing. Each side will lay out their points and present in the way that you would sort of expect a court process to be like. Unlike a typical courtroom, though, there are obviously different procedures, and the main pro of arbitration is that these proceedings are confidential. So if you're a company stuck in a dispute with another, something's gone horribly wrong, it can be very damaging to have your entire life laid out, your entire commercial life laid out in, the press. It can be damaging to your reputation. So if you have an arbitration proceeding instead, that's entirely confidential. It's also neutral. So if you have any reservations about bringing your case in front of a specific jurisdiction's court, then you can instead, arbitrate the entire process, and they're sort of seen as neutral parties. The cons are it's actually still quite expensive, less so than litigation. However, it's still cost. There are still costs to reckon with. Arbitrators themselves cannot enforce the ruling, but obviously they're actually much more enforceable than people initially think. And at the same time, the sort of main drawback is that an arbitration ruling the decision is pretty binding. There aren't really options for appeal in the same way that there are when you're litigating. I don't know if we'll mention it, but obviously in the UK, you have this system of appeals where if you're not a law student, you start at a lower level. And then if you appeal the decision, you keep going up and up and up until you can even get to the Supreme Court. That's what they mean by appeal system. And that doesn't really exist in arbitration. So that can be quite a big drawback. But yeah, that's a very sort of brief overview of what those different forms of dispute resolution are. But now we'll, I suppose, talk about what it is that actually goes on when you litigate something, because that is still the main way in which these things happen and the main way you'll learn about when you're a trainee. Ryan, do you want to take it away?
Yeah, so just going through the litigation process, it can be a very, very long process. The aim is for a case really to never get to court and for it to be settled beforehand, because obviously once you take, there's probably you got to issue the claim, which costs a lot of money. You've then obviously got to pay for barristers to actually go to court with you, obviously instructing the solicitors too. The process can be really long and drawn out, and you never know what's going to be kind of thrown up in the air during the case that could protract the proceedings any longer. The aim to settle before court first. There's something called the pre-action protocol. It's essentially a set of rules or procedures that claimants must follow before issuing a claim. So what will happen is you'll send out a letter called a letter before action, and it basically sets out the claim before any proceedings have commenced. It's kind of like an initial letter to prompt the parties to hash it out before they take it to proceedings. And failure to comply with the pre-action protocol can lead to cost penalties. So, for example, if you just skip straight to issuing, I'm not actually sure if you can do that without following the pre-action protocol, but if you skipped straight to issuing or didn't try as much to engage with the other party, went straight to court, then whatever damages you're awarded, whatever compensation you're given will probably be adversely lowered against you. So say you was going to be awarded 1 million, they might only give you 500,000 because you've wasted the court's time in not trying to settle first. So it's really important to try and encourage that engagement before you issue the proceedings. But then we move on to the next step. Letter before action's gone ignored by the other party. They haven't responded. They're not engaging. They just don't care. So you issue some proceedings. You'll issue documents like a claim form, which is just a short court document you have to fill out. It's just kind of a procedural thing. Very, very short. It just says what the type of claim is. You outline it very briefly, but then you'll do a more detailed statement of your case in a particulars of claim. So you'll outline the key facts, the legal basis, and also the remedies sought, and that's a lot more elaborate than the claim form is. Then you will schedule a directions hearing with the court. So the court will set a timetable and give directions for the progression of the case. So there'll be deadlines for things like disclosure. So that, as I said before, that's kind of you disclose documents to the other party that might be relevant to the case. Deadlines for submitting witness statements, so just obviously hearing from witnesses what has actually happened, and deadlines for submitting expert evidence and things like that. If you don't comply with those deadlines, the case can basically be thrown out, or you can get in a bit of trouble, or you'll have to ask for an extension. Then you're preparing for the trial. So you've met all those initial kind of steps that the courts are giving directions for so the trial can actually happen. If you haven't settled by this point, by the way, settlement negotiations will probably go on all throughout the litigation process. As I said before, it's a very protracted process, can be very lengthy, can be very expensive. So you want to settle at any point possible. So all the while this is happening, all the while these deadlines are in place, you will be trying to settle with the other party. So you're preparing for trial. Disclosure's taken place. The parties identify and share all relevant documents. They'll look through the documents, see if there's anything that can basically help their case or hurt their case, perhaps. And then you'll instruct counsel to attend court on your behalf. So counsel is just another word for a barrister. Barristers have rights of advocacy in court, so they can speak in court. Solicitors don't tend to or have limited rights to speak in court. So you'll draft a document called instructions to counsel. This is a very trainee oriented task. They'll always do it. Um, and you'll also have to draft various other court documents for the actual hearing itself. So, as I say, witness statement, which is just a written account of the facts from different witnesses, expert reports, and then also court bundles. So, um, I worked at quite a small firm before, so the court bundles I had to deal with were like, well, I say quite short. They were like 500 pages long. If you imagine that in some of these massive firms in the city, they're dealing with like these international banking disputes worth millions. The bundles you will see, literally just like a ring bound bundle. It will be perhaps thousands and thousands and thousands and thousands of pages long. You just have to send it to the court for it to be used in the hearing. Then there'll be the trial. So we've done all the preparation, go to the trial. Um, Fortunately, I haven't actually had to go to trial many. Oh, I haven't actually been to the court when I was paralegal, but most of our cases didn't end up there anyway. We'd settle before that. But there'll be opening statements from each side's lawyer, so that's kind of like an outline of the issues at hand and the evidence be presented. There'll be examination and cross-examination of witnesses, so basically just questioning your witness and then questioning their witnesses, etc., etc. Expert testimony, and then there'll be some closing submissions, so just kind of like the closing points before the case wraps up. Then there'll be a judgment, obviously. So that's the whole litigation process. There's a lot of parties involved that I mentioned. So the claimant, the person bringing the claim, the defendant, the party defending against the claim, witnesses, so people giving factual evidence, expert witnesses, so it'll be like independent experts who have specific knowledge on the subject, solicitors representing the claimants and defendants, obviously, and then counsel, which is the barristers who speak in court, and then finally litigation funders, which is something we'll touch on later that I don't think many people realize or is actually a thing, but it's a third party who essentially gives you money to fund the litigation. And if you win, they'll take a significant cut of that money because, as I say, litigation is very expensive. It's helpful that someone else can pay for it for you. But now that we touched upon the litigation process, we want to look at what trainees actually do. So, Julie, I'll pass it back to you if you want to talk about that.
Yeah, of course. I think what Ryan has given us is a really good overview of how much paperwork that and how long litigation processes, so how paperwork heavy and how long litigation processes can be. So as a trainee, you're going to be drowning in that paperwork, whether it's sort of part of that procedural work and making sure you're keeping to that timetable, because litigators are really governed by that timetable. And as you can see, there is real penalties for not sticking to it. So you're going to be drafting all of those documents and making sure that preparing all the court bundles, these huge, massive, are they still physical a lot of the time, actually?
Yeah, what you'll do is you'll make it on like a PDF, or we used to make it on some PDF software. And I think we'd file an electronic version with the court, but you also have to send a physical version to the defendant and also to the court. So you're printing out like 4 or 5 of these, and it's actually a very significant task to actually put it together, put the tabs in, label
Yeah.
it. Yeah, it's very arduous. It's one of those tasks that you just see on your diary and like, oh, God's sake, not today.
Yeah, no, that does not sound fun. But also, a lot of the time, you're not going to be, as a trainee, devising the sort of broad strategy of the actual process of
Mm.
litigation, but you might involve yourself in some legal research, researching certain points that might be useful for the senior associate or partner, whoever's managing the case on the high level. And oftentimes, you'll be drafting things, correspondence, pleadings. All of this paperwork needs to be drafted by someone. Ryan, do you have some more insight as someone who actually did a little bit of, I guess it is trainee level work really as a paralegal a lot of the time?
Yeah. There'll be, as I say, it's a lot of admin and procedural stuff. So you'll also attend like client meetings and conferences with counsel. So conference with counsel is just a meeting with a barrister to discuss your case before you go to court. You'll probably be sat there taking the meeting minutes, so jotting down what's being said, what's left to action, etc. And then there's a lot of admin stuff too. So I knew for me, we received letters back from the court after our directions hearing saying that you'd have to submit X document by this day, this day. And for the senior solicitor, she would always ask me, can you just go into my diary on Outlook and pop that in there for me? Because there'd be loads of dates we had to adhere by. So it's going around the team and popping all that in for them. I imagine if you're a trainee solicitor, you'll probably be doing that task as well, because you'll be the point of call for any action, any letters that come in for the court. Um, and then I think occasionally, it depends on what team you're in and how big the case is, but you might be responsible for analysing some of the evidence or the documents that is there, and maybe coming up with like a preliminary uh theory is probably the wrong word, a preliminary case for the claim at hand. I knew I did that a couple of times where I'd be handed kind of the liquidation documents and said, just look through this and see if there's any potential claims here. And then I'd talk it through with the supervisor. But I think mainly your job is very procedural, doing a lot of court documents, a lot of drafting though. There is writing particulars of claims and witness statements are quite interesting because you have to make sense. You have to kind of dissect everything that's happened in the case, put it in chronological order, and write in such a way that the court understands it. And first of all, you need to get to grips with everything that's happened to be able to understand that and convey it clearly. So it can be quite interesting. It's just very admin heavy in a sense for a lot of
Yeah,
the time. Mm.
I can imagine. But I suppose, what sorts of people do you think would be interested in going into this sort of area? Whenever I speak to litigators, the first thing they say is that obviously you need to have a strategic mind. You need to enjoy that sort of chess board type. Not saying that if you're not good at chess, you can't go into litigation. I'm terrible at chess, mostly because I refuse to get good at it. But you need to have a sort of strategic mind of figuring out what the best sort of procedure is and how to balance that with all of these very admin and heavy and court finicky bureaucratic processes, and so that balancing act is quite difficult. What else do you think makes someone well suited to litigation?
I don't know if anyone likes project management, but if you're good at project management, it's
Yeah.
probably good. Like juggling multiple deadlines, coordinating, liaising with various parties, making sure you're on top of everything. And also, when I was doing my work as paralegal, we maybe had 30 cases going on at once. It wasn't just like one big case, which is obviously going to be different at a bigger firm. But it meant that keeping on track of deadlines across multiple cases and also refamiliarizing myself each time with what the case was and what was going on there because it was quite different. Um, Guess you'd be suitable for it if you, as you say, enjoy analytical work, so dissecting the evidence, identifying inconsistencies, and like building a coherent narrative. If you like variety as well, the cases can involve very dramatically different facts each times and legal issues. It's probably not the area for you though if you want something with a quick turnaround, with a the disputes can last a very long time, and it can be quite. We had cases before where we went to the High Court down in London, and they literally settled at the door right before the day of like right on the day of the trial, and it's you put all that time and effort into get all the court documents in place. Everything's so rushed sometimes because you have so much going on, and it's oh for God's sake, you couldn't have just settled like a couple months back if you knew this was always going to happen. You just wasted everyone's time and ramped up the costs. It's just a bit annoying. So
Yeah.
if you want something with a quick turnaround, it's probably not the place for you. Maybe that's corporate work. Like the deals are much quicker there. Disputes can last for years here. And also if you prefer like collaborative rather than adversarial work, that's probably corporate type of work too, because you'll be working with the other side in that case to come to a mutual outcome. Here, obviously, in disputes, your interests are probably going to be at odds with each other, and you're trying to undermine's probably the wrong word, but pick out parts of the other party's case that aren't factually correct or aren't legally
Yeah,
sound to win.
absolutely. I mean, it's just a lot more confrontational. I
Yeah.
think we'll talk a little bit about the client experience, which I think is very important to bear in mind when you're applying to these massive firms with very commercially minded disputes practices. But speaking of different disputes practices, obviously, dispute resolution, sometimes there'll be a practice area. It will be a practice area that a firm has, and it just calls it quite generally, it's just called dispute resolution and investigations. and that's where they'll cover everything. But there are lots and lots of firms which have increasingly specialist disputes practices which hone in on certain areas that can be quite contentious. And I was wondering, Ryan, do you have a few that you could rattle off for us?
Yeah, so I've said before, drilling it home again, insolvency litigation. So that's all about investigating the circumstances surrounding a company's insolvency and pursuing the directors for any wrongdoing. So I'll give you some examples of claims because I think it helps bring each kind of area to life. And that's the point of this series, really. It's you've heard of all the different practice areas on a firm's website, but you might not be able to articulate what actually happens day to day there, or what the lawyers are doing, or what they're going after. So in insolvency litigation, some of the claims might be an antecedent transaction. So say a company's about to go bust, and the director says, you know what, I'll give this company give this company property to my son for free or for significantly cheaper. Because they've given this property away, it means you can't the liquidator can't sell that property, raise funds from it, and pay back the creditors. He's can't put it out of reach. With antecedent transactions, you say, look, you shouldn't have given that property to your son for free. We want the money back. So you claw it back from them and then give that money to the creditors. So that's one example. Director misfeasance, a director being dodgy and breaching his director duties, or wrongful trading. So that's where you continue to trade once you already know the company's going underground. And by doing so, you're just incurring further and further losses and there's less money to recoup for the creditors. So that's insolvency. Then you've got employment disputes, you've got your typical discrimination claims, uh, unfair dismissal, whistleblowing claims. So basically, like treating an employee detrimentally because of whistleblowing about some bad things going on at the organization. Redundancy disputes. What you'll see is with big law firms in the city, they're probably not going to be representing a single employee in like an unfair dismissal claim. That's probably going to be a high street firm because simply there's not going to be that much money in it. I think when I was at uni, I remember in employment law, I think an unfair dismissal claim was capped at like 80 grand or something like that. And that's not that much, there's not that many fees in it really. So if you look in the city, the work they're probably going to do is either representing senior executives or doing high value employment disputes, or maybe large scale group litigation, so big equal pay claims that affect thousands of people, or mass redundancies, and there's been issues there. There's going to be a lot more money in that for a big firm. Um, Financial services and banking litigation, so there'll be like fraud claims and investigations, mis-selling of financial products, breaches of regulation. Not that I know any banking regulation, but it's something that firms do. Competition litigation, you know a little bit about this. You want to mention something in this regard?
Yeah, sure. So we're obviously going to talk a little, I think we're going to talk a little
Mm.
bit
Yeah.
more about this during the class action section. But essentially, when companies are found to be being anti-competitive, they're, so a claim might be brought against them by a class representative, if they're being accused of cartel-like behavior. That's when sort of companies band together and they might fix prices as well. So, there have been loads and loads of examples of cases where representatives have brought claims against huge companies and there's been like 40 million claimants, and these cases tend to be massive, and that's why law firms get their fingers stuck in that particular pie. There's a lot of money in it. But there may also be work for law firms when it comes to these investigations by huge bodies like the CMA. And that's a thing to bear in mind, actually. Disputes practices are often paired with investigatory practices as well. And they sort of work hand in hand a lot of the time. But yeah, competition litigation is a particularly big growth area for law firms. There are lots of firms that don't do much litigation are looking into competition litigation, and I think that's something to bear in mind. I think IP is another big one.
Yep.
So intellectual property. This is pretty, this is fairly self-explanatory if you're someone who doesn't know much about law. If you infringe on someone's, if something's patented and someone starts using that, then obviously that's going to lead to problems. Music disputes, copyright disputes, all sorts of things that are quite live in sort of public perception surrounding law. And lots of firms have specialist IP litigation, especially now with AI, that's sort of raising lots of questions about intellectual property. Am I missing something? That there are definitely more, but also
Construction.
Construction litigation, actually, yeah. Oh, real estate litigation,
There
property.
are so many you could write. Yeah, construction, real estate, white collar crime and investigations.
Yeah.
Then in private client firms like probate, which is like dealing with the validity and interpretation of wills, family
Yeah.
law, so custody battles and divorce, immigration law disputes, medical negligence. There's like every
Everything.
practice you can
Yeah.
think of has like a dispute resolution equivalent. That is the thing. That is the thing to realize as well, is that there is a transactional employment practice, and then there's an employment disputes practice. Same with competition. There's competition transactional practice and competition contentious competition. I didn't phrase that very well, but
Yeah.
the transactional competition people will basically ensure that when a merger and acquisition is happening, that the kind of liaising with, if it's for a public company, they're liaising with the CMA to make sure that, I don't know, they're not breaching any competition rules by merging. It's not anti-competitive, blah blah blah. But competition litigation will take place once there's already been like a mess up, or they've done some anti-competitive practice and now they're being sued.
Yeah.
Um, so one's working together. Once again, it's like the transactional elements kind of working together with another party, whereas the litigation's kind of like, we're going after you. But there's
Yeah.
usually like a yin and yang, I guess you would
Yeah.
say.
Not every firm has this has this individual approach to litigation. It
Mm.
will depend on their individual specialties. I remember when we talked about lots of the mergers. Was it Winston and Strawn had a very big IP litigation practice, for instance, that
Mm.
specifically. But for instance, when I spoke to a litigation lawyer at Ashurst, or Ashurst Perkins Coie soon, she said, "Oh, I did something different like every time I did a new case. Like it was just so different that it was
Yeah.
almost like whiplash." So there's lots of variety. So look into the firms and see how they structure the way that they do disputes if that's something you're interested in. Do you want to briefly chat about legal tech? But just to see how it's sort of factoring in to the work that trainees and lawyers do.
A recurring theme in these podcasts, I feel. Uh,
Yeah.
and in training contract interviews, so it is useful. Yeah, so legal tech helps out quite a lot. It's simplifying the disclosure process. So, as I say, disclosure process, you're disclosing documents that's going to help or hinder your case. Technology assisted review can help reduce the time and obviously cost, because you've got to bill for doing the disclosure process, by helping go through these documents a lot quicker and highlighting any potential problems. It can accurately identify any relevant documents as well for you. Litigation prediction technology is another thing. I don't know too much about it, but it's basically being used to kind of estimate your chances of winning at trial based on specific judgments and previous cases of a similar sort, and how successful they are at winning. It's very interesting, but don't know much about it. Automation of procedural work, so drafting court forms automatically, or case management system. So every firm has a case management system. It's just where you kind of, every case gets a unique number, a matter number, we call it. You type in that matter number, you view your case and all the documents associated with that case in there. It's kind of just like having a OneDrive for uni and saving everything into a specific file. Like that is it. But every case has its own file, I guess, full of its own documents. Those case management systems are becoming increasingly more techy, I guess, or advanced, in that you can set filter for documents in there in ways you couldn't before. So just typing in a keyword or like describing a document you want, a case management system might be able to find out. Whereas before, you'd literally just have to type in the title of the document. And also AI assisted legal research. We covered that before. Websites like LexisNexis and Practical Law now have like an AI research function, which helps save time from having to, I don't know, read statutes or case law completely from scratch. But yeah, just moving on to the client experience. You talked about it a little bit earlier, Julia. If you want to touch on it again.
Of course, I think when if you're given a case study in a law firm interview and it's disputes related, the first thing, it will usually be commercial, but the first thing you should bear in mind, obviously, litigating, as we've said, expensive, very stressful, time consuming. It can damage reputations immensely. Just think about like the Johnson and Johnson case from a couple of years ago. So that's one thing to really bear in mind. If you're working as a lawyer on these cases, you're dealing with people who are feeling particularly fragile, even if, it's not their personal skin in the game because it's a company. It's a stressful experience to go through. And sometimes the best legal solution isn't necessarily going to be the best commercial solution. I spoke to a partner at a law firm, and she was telling me about an employment dispute. They were representing the employer, and essentially what had happened was that they had found completely, like, they were completely within their right to dismiss this employee that they were stuck in a dispute in, without notice, because he had breached a term in the contract. It was very legally clear and simple. However, they decided to advise them against it because, first of all, the company was quite small. I think it was a charity. Everyone was extremely stressed out by the entire process. If they decided to dismiss this employee without notice, they were sort of, they knew that the employee was quite litigious and would probably want to appeal that and would like try and make a claim, and it would turn into this whole thing. So they knew that that would stress everyone out. There were sort of like 15 people working there, so it was very, very close knit. It would damage the reputation of the charity. It would cause all sorts of problems. So they decided to give him his regular 6 months, and just do away with it. And that's an example of where client management means that the commercial solution isn't necessarily the same as the legal solution, but it is ultimately the best one. So you're going to be dealing with people who need support, who are stuck in difficult, situations. As one lawyer said, transactional law tends to be flying the plane. Disputes is picking up the dead bodies and the pieces of plane, in the middle of the Atlantic. It can be stressful. And so it's not exactly a calm environment to work in. And that needs to be, kept in mind. You're going to be stressed. If you find that exciting, that's fine. And it can also really, really drag out. I think the next thing we're going to be talking about is sort of key trends that are really shaping disputes work and litigation more specifically. Are we good to go on that, or did you have anything else to add for client experience?
I'd just say maybe that you'd want to hire the best lawyers when you're drafting a contract in the first place. You want to make sure that contract is absolutely watertight and that there's no room for interpretation or ambiguity, or you want to make sure every single risk is allocated and every single eventuality is covered. So if you're drafting, like, I don't know, an exemption clause, for example, where you want to kind of limit your liability for something happening, you just want to make sure you thought about every single consideration that could potentially happen there, and make sure the risk is on one party or another, so that it just doesn't get disputed and that everyone knows that ahead of time. I think the only way to get that is to hire the best, like, lawyers in the city to draft your contracts, who've literally experienced every single nightmare possible, who've got the experience to understand what needs to be in there, what doesn't, etc., etc. So I think just thinking about it a bit more in advance, so you don't have to get to the disputes part in the first place. But yeah, I'm happy to move on to key trends in dispute resolution. I think I'll start with climate litigation because that's something I'm a little bit interested in. I think we spoke about this before in previous podcasts. Quite a lot of the reading I was doing going into my training contract interviews was to do with kind of renewable energy and climate litigation, sustainable, like net zero transition type of stuff. Anything of that sort of kind of uh ilk. I don't know. I can't think of the word I need. Anything of that sort of sphere. Let's go for that. I was interested in. It took me a while to get there. There's probably a simpler word, area. Let's go for that. But yeah, climate related litigation is becoming increasingly common. What you'll see is that maybe activist groups or individual people are trying to sue kind of big corporates or governments for failing to adhere to their own climate policies that they put in place, or contributing to climate change significantly through their activities, or maybe greenwashing or related claims. There was a case in the Netherlands a couple of years back, say a couple of years back, like 2 or 3 years ago. I can't remember the name of the activist. I think it was Friends of the Earth, something like that, versus Shell. And they were suing Shell for it was either not adhering to their own climate policies, or just their significantly bad impact to the planet. And I think at first it was successful, but it was overturned on appeal. But there's been lots of cases like that recently where big petrol companies are being sued by activist groups. That's just something to be aware of in this area. I think it's quite interesting, and you'll see that quite a lot of firms are developing like climate practices now and net zero practices beyond just their normal energy practice that they had before. If you go on the website, you will see a whole section of where it says capabilities and insights, and it will say climate change and things like that. So I think it's quite an interesting area to keep your eyes on. Do you have anything? I know you have a few things to speak about, so what a redundant question. Do you want
Yeah,
to speak
sure,
about some trends in this area?
sure. I think, gosh, I don't know if you can hear the
I can hear the
alarm.
Nino.
Oh, we'll let it pass. Goodbye. Okay. Anyway, so I think one of the things that has really changed over the last decade or so is the number of class actions that have been sort of taking place in the class action lawsuits that have been happening in the UK. And what a class action lawsuit is obviously is like if there's lots and lots of different people affected by one thing, they can all sue, usually through a class representative. But what changed in sort of 2015, I think, was that the UK introduced under, I think it's called the Consumer Rights Act, the opt-out regime, which basically meant that if you could demonstrate that something had been done to a class unfairly, and that it was sort of 40 million people or something, you would not need everyone to write and say, yes, I want to be part of this, I'll opt in. It automatically includes everyone that's affected if you can demonstrate that that's the case. What this essentially means, this has mostly been limited to competition law, this development in particular, is that classes have become massive, huge. I say 40 million a lot because one of the biggest class action lawsuits in the last couple of years was one between MasterCard, obviously card as in the actual like transactions, and the class representative Walter Merrick's. Essentially, the whole point was that MasterCard had been unfairly charging its customers on sort of interchange fees that you get when you use your card in like a shop. Usually the shop covers that difference. It's like a little transaction fee, but they were essentially raising their prices and making things more expensive for consumers. This happened in the late 90s and early 2000s. And essentially, what they did was said, right, do you know how many people have been affected by this? 46 million people.
Oh, you was going to say billion then. I was like, hmm.
I was like, no, God, no. But the
Hmm.
claim itself was valued at 10 billion pounds. So that is a huge amount of money. And there are lots and lots of these different class action suits that are popping up. This is just a very famous one because it came up in the press for reasons we'll talk about in a second. And what this essentially means is that lawsuits are, they're becoming larger, they're taking longer. This particular one took sort of 9 years. And the reason that they're able to do this, because you think about a claim of that size, must be quite expensive to litigate for that long, and for that much money. Well, that's where litigation funding comes in, and that's particularly pertinent with this case. Litigation funders, as Ryan mentioned earlier, they come in and they say, all right, you have this claim, we'll put down a certain amount of money, but then we want a cut of the settlement afterwards. So in this case, the originally valued 10 billion, they were like, actually, we want some of that. And what this does is that obviously it opens up the opportunity for people who have been adversely affected by, unfair prices to be able to actually make these claims. Because if you're a regular person who's been overcharged as part of a big class, as part of this large class, you're not exactly going to be able to go and litigate yourself and hire all these top city law firms and go up against a huge behemoth like MasterCard. So that's the argument for litigation funding, because it opens up the opportunity for regular people to get their money back. However, does this actually happen is another question. There was a big controversy with this case because they settled for much less than they initially wanted, like 200 million. So people would allegedly only get like £2 back when they were originally meant to get 70. And the funder was not pleased. They were angry with the law firm, and it was just a huge mess up in the press. But it's still very important for getting these cases through and over the line. And there was this decision in the Supreme Court, which takes us to the next question, which basically said for these huge opt-out class actions, you can't really use litigation funding in the same way. Why? They basically said, that the payment model of receiving these massive shares of money once you've, as the litigation funder, have put down some money and said, I'm going to get a cut afterwards, is unenforceable. And that means that, you can't fund these huge opt-out class action lawsuits and then get your money back. You can't do that. It's a damages-based agreement. It's not allowed. It kind of makes sense because if you think about it, you could exponentially scale a class to almost like 1 billion people. If you said, how many people use like a Microsoft computer? Microsoft has done something wrong, so we're going to sue for on the behalf of, I don't know how many people use Microsoft computers, but a large number. So think about how much money there is in that. And suddenly all of these litigation funding agreements became null and void. And that made a lot of litigation funders very nervous because it's a very big business now, and it's how law firms get a lot of their business. The UK is moving to reverse this ruling. This was called the PACCAR ruling, if you want to look it up. It was in the Supreme Court, PACCAR, because it related to trucks, a truck manufacturer. And sort of there was a whole claim against them in particular. But from that judgment, they essentially said, litigation funders, you can't get a slice of the pie if it's an opt-out class action lawsuit, which it was. That was like a massive cesspool of information, but it's something I find quite interesting. I'm very bad at talking about it coherently. Ryan, have I missed anything?
No, I also really like competition litigation. It was something I spoke to a Wilkie trainee and senior associate on an open day a long time ago. Um, and one of the things I mentioned to them was that I wonder if litigation funders are trying to be opportunistic about trying to contort claims into this new competition law framework. So I went to a Herbert Smith Freehills open day as well, and they spoke about a competition law case they had done, or a competition law case. I'm doing air quotes if you can't see. It didn't really feel distinctly. It didn't have a competition flavor to it, but it felt like they were trying to contort the facts so it fit within this new competition regime. It was
Yeah.
clearly like worthy of a class action, but the standard class action is an opt-in. So you have to say, I want to be included in it.
Yeah.
With opt-out, you're automatically presumed to be within it and you got to opt out, which no one will probably do. So the classes are much bigger, there's a lot more money. So the fear is that, or at least my fear would be, or my thought would be that litigation funders are going to be a lot more opportunistic, try and like work with law firms to find claims, pigeonhole them into the competition law regime, and then be like, oh, there's 50 million people affected. That's X,
Yeah.
that's 200 million for us to pocket. But yeah, I think it's a really interesting area too. It's up and it I was gonna say it's up and coming. It has up and came already
Yeah.
over the past few years.
I agree with you. I do think, and that's exactly what happened during that dispute with MasterCard, is that they got the firm which got into an argument with the funders was accusing them of trying to drag out proceedings and
Mm.
trying to basically squeeze cash. And then the funder, on the other hand, said, yeah, but you should have settled for more because this isn't enough, claiming that it was for the benefit of the consumers. But you can sort of look at it and be like, let's see if this is your entire business model, is funding these lawsuits, which it is, by the way. This is a lot of the time, this is what they do, this is their primary business model. Then you sort of think there's a bit of a tension there. It will probably sound very impressive if you bring it up in a training contract interview. I remember I asked a question about litigation funding at an event once, and they said, how do you know about that? Like, how do you students know what that is? I was like, I was just trying to be keen. I'm sorry. There are a few more things that I think are quite important. Do you want to talk a little bit about the Mazur judgment and what that means for litigation?
Yeah, I mean, I've been seeing it all over LinkedIn for months and months and months since it happened. Now it happened sometime late last year. I can't remember when. But it was could have been the Supreme Court. I can't remember. One of the courts said that. I'll go with it. I'll say it authoritatively. The Supreme Court said something along the lines of only authorized individuals can conduct litigation, and that's the key word, conduct. The issue with that meant that the definition of conduct litigation wasn't too clear. Like, how do you distinguish conducting litigation from supporting litigation? Importantly, paralegals and I think legal executives, I think it said in the case as well, and like legal assistants and things like that, aren't authorized individuals, so they would not be able to conduct litigation after this judgment. It caused a lot of fear, especially in, I imagine, small firms where their models, a lot fewer senior associates, a lot fewer partners and lots of paralegals who take on a big chunk of the work. So they now no longer knew what can a paralegal do and what can't a paralegal do, because it's kind of disrupted the business model that might have been in place, which shouldn't have been in place because of this ruling. They're saying that this is how the statute should have been interpreted the entire time. You shouldn't have done this anyway. But it's kind of not being corrected or spoken about until this case, I feel. I'm not sure what's happened now. I think the SRA might have issued some guidance on what can and can't be, but I think there's still issues of how clear it is and what we can and can't do. Um,
Yeah,
but yeah, it's just a bit scary not knowing how to operate, I guess, and how this affects law firms' business models.
exactly. And I think another thing that has made the law firms quite nervous is that clients can come back and challenge some of the work that they did previously. Also, it was a high court ruling. I looked it up just in case.
Thank you.
But yeah, so it's just leaving people in a bit of a state of limbo. And yeah, it's sort of important to bear in mind because this naturally affects trainees as well. I'm not sure. I think there have already been. I think some parties have already brought things to the courts. Like it's already
Mm,
affecting law firm work in a material way.
yeah.
Um, so yeah, it's very risky. It's not very good. I think did we have one more thing to talk about?
Just the rise of alternative dispute resolution in general. I think
Yeah,
parties are wanting to use whatever they can to avoid going to court. I mean, as we say, court is very, very expensive. It can be a very lengthy and protracted process. It also just destroys any commercial relationship you have with these people. And the court system's so incredibly congested. Like as I say, like it's a long time, but trying to get a big dispute booked in, it might be years before you've actually like issued the claim before it gets litigated. And during that time, anyway, so much can happen. Like you just might get. I mean, it's a bit simple to say. I was gonna say you might just get a bit bored. In that meantime, it's just like, is this worth pursuing anymore? We've waited 3 years, and you might just. I think parties are trying to encourage or do anything to settle before it gets there. So using things like putting arbitration clauses in the contract or mechanisms for resolving any disputes they may have, so it doesn't go to court, or maybe encouraging mediation. As we say, mediation isn't binding. It's just a third party mediator will be there to kind of help the parties facilitate and come to a they come to like a conclusion they're happy with. But that decision isn't binding. But I do think we're probably going to see a rise in it just because of how expensive and long courts are at the moment.
yeah, absolutely. Well, we hope that's given you an insight into, well, what it's like to work in dispute resolution and hopefully given you some inspiration for your own research. None of what we said is remotely exhaustive, as I think we say every time we host an episode. So please make sure to go and explore the things that we've mentioned, as it's absolutely fascinating as an area. There's so much going on right now. There's so many developments. And as Ryan and I have said many times, there are so many different kinds of disputes that are peppered throughout the legal world. We'll be back next week, hopefully with another practice area or something different. We haven't decided yet. But we hope you have a lovely rest of the week. And yeah, see you next week.
See you next week, guys. Just a whistle stop tour, we'll call it. I think
Yeah,
that's I think that's
whistle
fair.
stop
Yeah.
tour.
Whistle stop tour through dispute resolution. Yes, we'll decide what we're doing next week. We don't know yet. But thanks for listening, guys.
Thank you. Bye bye.